Good morning, I'm Gary DeWaal, and this is Bridging the Week for March 14th to 18th, and today is March 21st, 2016. Despite multiple requests, the Commodity Futures Trading Commission declined to extend the comment period for its proposed regulation automated trading that expired last week. Instead, by March 16th, the comment period expiration date, the CFTC received approximately 50 written views that often criticize both the too broad reach and exclusion of certain algorithmic traders from the scope of Regulation AT, as well as the prescriptive nature of the proposed rules. In addition, last week, both the CFTC and the European Commission formally recognized each other's oversight of clearinghouses as equivalent. I need to fly to Toronto for business this week, so I'm not late for my plane. Let's get started. After declining multiple requests to extend the comment period that expired on March 16, 2016, the Commodity Futures Trading Commission received approximately 50 written responses to its proposed regulation automated trading. A wide range of responders, including trade organization vendors, market participants, academics, public interest groups, and individuals, wrote comments. Although responders generally approved of the CFTC's objective of ensuring robust controls, transparency measures, and other safeguards to mitigate risk arising from algorithmic trading on derivatives contract markets, the majority of comment letters criticized the proposed rules as too prescriptive. The most passionate specific objections were raised regarding proposed requirements mandating that certain persons engaged in algorithmic trading who directly access derivatives contract markets be registered as floor traders, and that all so-called AT persons maintain source code in a distinct repository subject to inspection by CFTC and Department of Justice staff. Those raising these concerns claimed that registration requirements were unnecessary and that it was untenable that source code could be made so easily available, thereby potentially exposing the lifeblood of a trading business to ruinous inadvertent disclosures to third parties, including competitors. Regulation AT, proposed by the CFTC last year, is a comprehensive set of rules designed to reduce the risk of algorithmic trading on designated contract markets and to increase market transparency. In a speech last week before the FIA's annual International Futures Industry Conference in Florida, CFTC Chairman Timothy Massad expressed his quote-unquote hope that the Commission would finalize Regulation AT by year-end. He promised that any final rule would respect and protect the confidentiality of source code, quote, while at the same time ensuring that source code is preserved and is available to us when we need to reconstruct market events, end of quote. The CFTC issued an express determination that certain laws and regulations of the European Union applicable to clearinghouses are comprehensive and comparable to those under which clearinghouses registered with the CFTC operate. As a result, going forward, the CFTC will permit European-based clearinghouses that are registered with it as derivatives clearing organizations and are also overseen by a European national regulator to comply with local requirements to satisfy equivalent CFTC requirements regarding their financial resources, risk management practices, settlement procedures, and default rules and procedures. Simultaneously with the CFTC's and staff actions, the European Commission issued a formal determination that the CFTC has equivalent requirements as the EU in overseeing clearinghouses. This paves the way for derivatives clearing organizations to apply to the European Securities and Markets Authority for recognition to clear exchange derivatives transactions for EU-based persons and to obtain qualifying CCP status so that European banks will not have to take a large capital charge to clear transactions through them. Equinox Fund Management LLC settled charges brought by the Commodity Futures Trading Commission that, from 2004 to March 2011, it made material misstatements and omissions in connection with its operation of a multi-advisor commodity pool known as the Frontier Fund. Specifically, the CFTC alleged that, during the relevant time period, Equinox, a CFTC-registered commodity pool operator, assessed management fees based on the value of Frontier Fund's notional assets, meaning invested assets plus leverage. However, the fund's disclosure documents advise investors that management fees would only be assessed on the fund's net asset value. In addition, the 2010 annual report for the Frontier Fund said that the value of certain over-the-counter options held by the fund were, quote, corroborated by weekly counterparty settlement values, end of quote, when this was not the case. The CFTC's enforcement action followed by 2 months Equinox settlement of a similar action brought by the Securities Exchange Commission for the same underlying facts. And finally, IBFX Inc., a Commodity Futures Trading Commission registered retail foreign exchange dealer and swap dealer, resolved charges brought by the CFTC and the National Futures Association that it failed to meet minimum capital requirements from January 15, 2015 through February 5, 2015, and did not immediately notify each regulator of its failure as required. According to each regulator, IBFX failure resulted from the unexpected collapse of the Swiss franc in relation to the euro on January 15, 2015. As a result, customers of an IBFX Australia-based affiliate sustained losses of approximately $4 million that the Australian affiliate then owed but did not pay to IBFX. However, IBFX did not fully recognize this shortfall, as well as the fact that it was actually undercapitalized by as much as $9 million during the relevant time, until it completed its month-end reconciliation for January 2015. As a result, charged both regulators, IBFX did not notify the CFTC and NFA that it failed to maintain minimal capital requirements during the relevant period until February 5, 2015. In addition, NFA charged IBFX and Herbert Walton, IBFX's chief compliance officer, with IBFX's failure to adopt and implement, quote, effective procedures to adequately monitor the firm's compliance with applicable SD or swap dealer regulatory requirements, end of quote, and with failure to take reasonable steps to ensure IBFX implemented an adequate risk management program. To resolve the CFTC's complaint, IBFX agreed to pay a fine of $1 million. However, to resolve NFA charges, IBFX also agreed to withdraw its NFA membership by March 30, 2016. NFA's complaint against Mr. Walton was dismissed with prejudice. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article, and more articles, including my views on Regulation AT, on the article version of Bridging the Week on the website. Check it out. Until next week, I'm Gary DeWaal. Actually, I'm Gary DeWaal through next week. And until then, ciao.